Well, good day and welcome back. Before we begin, let's just cycle back for a moment to the previous episode in which we talked about compliance risk management and cyber risk management. And we posed the burning question, what's the problem we're trying to solve? Are we trying to be compliant or are we trying to be secure? And the answer is yes, we're trying to be both. In fact, I think we ended the session or the episode by speaking about the fact that if you're compliant, it does not necessarily mean you're secure, and vice versa. The two are inextricably linked. So in this episode, we're going to do a bit of a sidebar by focusing on compliance within the HIPAA Security Rule and around a concept that I'll call standard of care. And within HIPAA, there are three definitions. I'm going to refer to them as elements of standard of care for purposes of our session today. And those three that we're going to be covering are reasonable diligence, reasonable cause, and the concept of willful neglect. Before we dive into the session, just as a reminder of where we are in our journey, this is how we're intending to achieve our overall objectives that we set forth in the introductory session, and to cover three themes that I introduced at that point in time, which were about context, the role of our C-suite and board, and everyone in the organization for that matter, and finally, certain best practices. In this episode, even though I'm not an attorney, I'm not practicing law, I haven't slept in a Holiday Inn Express or however that ad goes, we are going to talk about some terms that are legal in nature. And so this is important because we're getting at risk and liabilities from a high level, at a level that your board and your C-suite, I'm confident, will appreciate knowing about. As I've mentioned, we anticipate that there'll be a total of 25 or 30 episodes comprising this series. They'll be available on this YouTube channel. If you've not subscribed already, please do so you don't miss out on any new postings of episodes or materials. And then finally, feel free to share this with any of your friends and colleagues whom you believe might benefit from these sessions. So let's get into the meat of the matter. I'm going to build out this slide and we'll go through each of these in turn. The HIPAA language related to the standard of care includes these three terms. And importantly, these are fundamental definitions that tie into, later on, we'll talk about more broadly, if you're a member of a board of directors, you have fiduciary responsibilities. You also have a duty of care. There's a relationship between these terms that we're talking about today and some other legal concepts that we'll cover a little bit later. HIPAA weighs in on these three terms in the following way. And this is probably amidst all of the slides and topics we're going to be talking about, if there's one that you want to print and post near your virtual water cooler or to share with your C-suite and board, it's probably this one. So first of all, there's a matter of reasonable diligence. That is exactly where you want to be. Fundamentally, reasonable diligence means that you're doing the kinds of things that anyone, a prudent person, would be doing if they were really striving to comply with the regulations. And in this case, it's all of the privacy rule, security rule, and breach notification rule, although our focus is primarily on the security rule and risk management. So what does that translate into? What it ends up meaning is that you have in place good oversight of your privacy, security, and breach notification activities. You have policies and procedures in place. You're undertaking training. You've done things like risk analyses. You have a risk management plan. You've done other evaluations that are required, for instance, under the security rule. You have policies and procedures around appointing your privacy and security officials, etc., etc., etc. That's living in the land of reasonable diligence. If you want a different view of it, I would encourage you to check out the OCR audit protocol. There's a link to it in the references and resources material. And also check out the Office for Civil Rights Enforcement Actions. Again, I've provided a link to that. They'll give you some insight into the opposite when people are not being reasonably diligent. So we move next to a flip, as I mentioned earlier. The opposite of reasonable diligence is living in the land of reasonable cause. In this particular circumstance, what you're demonstrating is that you've not exercised any sort of reasonable discovery work to find out what your obligations were under the privacy, security, and breach notification rules. And in fact, not only have you not done the discovery work, but you're not behaving in a way that a prudent person would behave in if they were really striving to comply with the regulations. So what do I mean by that? It fundamentally means you should know by now. After all, it's 2021 as we're recording these sessions. Privacy Rule was published in the Federal Register in 2001, became effective in 2003. Security Rule was published in the Federal Register in 2003, became effective in April 2005. It's really inexcusable to not know that you have obligations under those regulations right now. Last but not least is the worst case condition, as the words indicate, conscious, intentional failure, reckless indifference. Fundamentally, what this means is lights out, hard stop. You have not paid any attention to what you ought to be doing. As I mentioned, these regulations are not exactly a newsflash. How would we know willful neglect if we saw it? If you're a healthcare delivery organization today and you do not have a notice of privacy practices, that's a tip-off. If you've not done risk analysis, if you haven't appointed security officials, unfortunately, you're not even trying. And I've seen all of these in numerous cases in numerous organizations with which we've worked, and in certain circumstances where I have served as an expert witness. OCR uses these definitions in a couple of different ways to evaluate at what level you have undertaken your obligations and your responsibilities. And then secondarily, they're used to determine at what tier in the civil money penalty system your potential fines or penalties would be derived or calculated. So we won't go into the fines and penalties at this point in time, and I won't go into these terms any further in this session. We're trying to maintain some brevity here, but I have included some really good references and resources in what follows. So by way of wrap up, what we've covered in this session is the concept of a standard of care under which we define three terms that I believe are critically important for you to understand and for your board and your C-suite and your colleagues to understand as well. I would encourage you to share the slide. I would also suggest that you have a conversation about where your organization stands with respect to those three terms. Were you ever subjected to an OCR enforcement action? And remember, those three terms determine level of culpability and also drive what OCR looks at and how they calculate any potential civil money penalty. So as I've always done, I'm ending this session with some suggested actions as well as references and resources. I encourage you, while the material is fresh in your mind, to undertake some of those actions and to consult with some of the references and resources. In the next episode, we're going to get into the matter of three elements or factors that must be present in order for someone to file a medical malpractice lawsuit. Quickly, those are, there has to be a violation of a standard of care, number one. Number two, there has to be injury present. And number three, there has to be a link. There has to be causation between the failure to follow a standard of care and the injury or harm that occurred. We're covering this because there have been long-standing standards of care in a clinical setting and in the medical world. What we're seeing now is an emergence of standards of care in the enterprise cyber risk management world. Take, for example, the HIPAA Security Rule can be regarded as a baseline standard of care. And certainly all of the materials that have been produced by the National Institute of Standards and Technology, and most notably the NIST cybersecurity framework, is serving as a standard of care as well. So I would encourage you to ask the question, Where are you relative to the standards of care we discussed today, reasonable diligence, reasonable cause of willful neglect, and where are you relative to some of the practices that have been and standards and guidelines that have been put forth by NIST. Until then, subscribe, be well, be secure, and see you in the next session. Thank you.